Hello, guys. Welcome to our YouTube channel. So we're having a series, and this series will be on lectures for the Nigerian Law School. We're going to be touching on all the topics, and the idea behind this is to break every topic down in the easiest way possible. So where you find it difficult to understand in class, when you listen to this audio, this video, and you watch this video, you will be able to understand everything. And if, of course, there are some things you're unable to understand in the course of the explanation, you can drop your comments and your questions in the comment box. Okay, so we have different courses in the Nigerian Law School. We have property law, we have corporate law practice, we have professional ethics, we have criminal law, and we have civil law, civil litigation. So today we're going to pick up a topic in property law practice. Okay, and the topic for today is deeds. If you have attended the classes of the Nigerian Law School, one of the topics you would have come across in the course of your lecture is deeds. And of course, we have deeds that are used for different kind of property transaction. But you need to understand what a deed is and the instances where you will use it, instances where they won't be required, and how to draft some of these deeds. I mean, you need to understand everything about deed, particularly for your bar finals. A deed generally is a document in writing which furnishes evidence or information about something made of paper or the like, and it is one which is signed, sealed, and delivered. So a deed is generally described as a document signed, sealed, and delivered. So it must effect the transference of an interest or right in property. If you are transferring an interest, a legal interest in a property, you must transfer it by way of a deed. It creates an obligation binding on some person or persons generally. Also, a deed confirms some act whereby an interest, right, or property has already passed. You will now want to ask us, when is a deed required? When is a deed required? Now, when you are making a contract that has no consideration, generally, for there to be a binding contract, you have the offer, the acceptance, the consideration, intention to create legal relationships, and capacity to contract. But there are instances where you contract and there is no consideration. Such instances, the document, the agreement must be by deed. It must be signed, sealed, and delivered. An instance, for example, is gift. So when a man wants to give a land to his child, and of course he doesn't want the child to pay for it, that means no consideration has been furnished. It is given by way of gift, and the document you prepare is a deed of gift. So when a contract is lacking in consideration, you need to use a deed to consummate that contract. When do you need a deed? Secondly, when statute so provides. So there are some provisions in statute that specifically says this kind of transaction has to be by deed. So for example, if you look at section 77 of the PCL of 1959, of course you understand the PCL applies to states in Western Nigeria and Midwestern Nigeria as far as property law is concerned. So where, for example, section 77 of the PCL provides that certain transactions should be by deed, then it has to be by deed. Then a power of attorney vesting power in an attorney to execute a deed must itself be by deed. So let me explain this. So if the power you are giving to an attorney, vide a power of attorney, is for the power, if it's for the attorney, you are the attorney you're giving the power you're giving to him is for him to be able to execute a deed, then that power of attorney must be by deed. So if you are saying, I grant you the power to sell my property, of course, if you want to sell a property, transfer legal interest, it has to be by deed. Then the instrument, the power of attorney, through which you have given that your attorney the power, should be by deed. Then a lease for a term exceeding 3 years has to be by deed. Now that means tenancy agreements, of course, they don't have to be by deed because they are less than 3 years. So for a lease of a term exceeding 3 years, it has to be by deed. Again, to give effect to a vesting declaration, So you use a deed to give effect to a vesting declaration. Then also a surrender where a lesser estate is given up to merge with the greater estate in land. By way of a recap, when is a deed required? One, when you have a contract lacking in consideration, for example, a deed of gift. Two, when statute provides. Three, a power of attorney vesting power in an attorney to execute a deed. Such must be by deed. Of course, you would have seen the case of Abina and Farhat. If you have the time, try to read up that case. A lease for a term exceeding 3 years has to be by deed. Then a surrender where a lesser estate is given up to merge with the greater estate in land. I just mentioned transactions that has to be by deed, or instances where a deed is required. Now, what are the instances where a deed is not required? Number one, for assents. For assents, of course, assents can also be referred to as vesting assent, and it is an instrument by which a person's representative, or the personal representative of a deceased person, conveys land to the beneficiary entitled to it. So someone is a testator or a personal representative of someone who has just died, and of course he holds the property or holds the estate for the benefit of beneficiaries. So if he wants to convey that land or that estate, that property, to the beneficiary, the means of conveying it is an asset and doesn't have to be by deed. All right. So in that case, the beneficiary may be a devisee under a will or the next of kin of a deceased intestate. That is a person who died without making a will. If he dies making a will, that's a testate. We'll talk about that when we talk about wills and codicils. So one, transactions not required to be by deed, assents. Then you have surrender by operation of law. A surrender by operation of law usually takes effect by implication. For example, where a lessee accepts a new lease incompatible with his existing lease. So it's more like it implied surrenders. Implied surrenders need not be in writing to take effect. All right. So now a lease or tenancy for a term less than 3 years. I just told you earlier, for tenancies, annual tenancies, for example, it need not be by deed. Vesting orders. Vesting order basically is an order made by a court to create or transfer a legal estate in land. It is made by a deed of conveyance. So, for example, where an equitable mortgagee exercises his power of sale, the court may make an order vesting the land in the purchaser. All right. So we'll talk about that more when we get to mortgages. Then conveyances taking effect by operation of law. Such do not have to be by deed. Disclaimers, right? Does not have to be by deed. But what do you mean by disclaimer? Let's explain that. So for example, where a trustee in bankruptcy seeks to disclaim some property forming part of the bankrupt estate. Also where a beneficiary, for example, who is sui generis, unique, refuses a gift under a will without doing so in writing. Such a disclaimer is implied by conduct and so not required to be by deed. So you are refusing to take the property. You don't need a deed to refuse to disclaim ownership. Then transactions covered by the rule in Wash and Lonsdale. In your undergraduate days, you must have been taught the rule in Wash and Lonsdale, right? It is basically one that says equity sees as done that which ought to have been done. So the rule is that an instrument which is void as a conveyance because it is not a deed may still operate in equity as an agreement, right? So if an agreement is supposed to be by deed, the fact that it is not by deed does not necessarily void the agreement. So that's the principle in Wash and Lonsdale. So let's go over again. What are the transactions not required to be by deed? Assents, surrender by operation of law, a lease or tenancy. Let's not even say a lease, a tenancy for a term less than 3 years, receipts, not required by law to be under seal, vesting orders, conveyances taking effect by operation of law, disclaimer, and transactions covered by the rule in wash and loan stay. Now, this takes us to the next point, the essentials of a deed. Number one, so when you are asked what are the essentials of a deed, number one is signing. At the beginning of this course, I told you that for a deed, it has to be signed, sealed, and delivered. But of course, you need to understand what it means when you say something is signed, sealed, and delivered, right? So the first essential of a deed is signing. So a deed must be signed. That is, it must be executed by parties to that deed. All right. Then the next one is sealing. What are the essentials of a deed? One, signing. Two, sealing. Now, this is a time-honored and ancient essential for the execution of a deed, which is becoming less and less important. So you see those red parchments, being attached to a deed. It used to be the practice in olden days, but now it is now becoming less attractive. In fact, the formalities with regard to sealing are now minimal, and any indication of an attempt of sealing will be accepted for the purpose of due execution. So anything that takes the place of that red parchment that appears to show that, okay, parties have sealed this contract. In fact, by merely saying you have sealed it, it covers for that that requirement. Okay. And again, so when you are having an agreement with you're having a deed with a company, under the old karma, the seal of the company is required to be affixed to such an agreement. But of course, under the new karma in your corporate law, we'll come to that when we talk about those issues under corporate law. You need not necessarily affix your company seal, because a limited liability company need not by compulsion have a seal. All right. So the days of you having to affix a wax or a wafer are long gone. So anything that evinces the intention to affix a seal satisfies that condition of you affixing a seal. So you can see the cases of First National Securities and Jones. You can also see the case of Containers Nigeria Limited versus Lawschool Limited. Now, the last one is delivery. What are the essentials of a deed? Don't forget that is what we're talking about. Number one, signing. Number two, sealing. Number three, delivery. Now, this is also an essential element for the due execution, all right, of a deed. A deed takes effect not necessarily by parting with physical possession of the deed itself. So you must understand. So because literally, when you say delivery, what comes to mind is you deliver something. You take something. Just imagine you order food from Jumia Foods. When they bring it to your office or to your apartment, it is said that it has been delivered to you. But it is slightly different in this case. Mere delivery of the deed without requisite intention to pass the interest to be conveyed by it will leave execution incomplete. Let's even look at the history. It used to be the practice for parties executing deed to utter the following: I deliver this as my solemn act and deed. But it is now accepted that no such form of words is necessary, really. And that any act of the party showing that the deed is intended to be binding upon him, is sufficient evidence of delivery. So you get the gist. Now, a deed is valid when, even if it has no date, all the deeds of assignment that you draft, they are undated. All right. So even if you don't date a deed, it is still valid. In fact, if it has a false or impossible date, it is still valid. Surprised? See the case of Jegede and Citycon Nigeria Limited, 2001, 4 Nigeria Weekly Law Report, part 704. Look at page 112. A deed is valid even if it has no date. If it has a first date and an impossible date, it is also valid. All right. Now, once a deed has been executed, even in escrow, it is too late for the executing party to escape from its effects, provided that the other party fulfills the condition within a reasonable time, if any, is not specifically provided for. So, when you talk about escrow, what does that really mean? What does that really mean? So, escrow means more like you're depositing it somewhere, right? So, it is not in the possession of any of the party, it is maybe with a third party agent who holds it for the parties. So, these are very, very important things that must be understood about a deed. Now, if a deed is to be executed outside the country for the purpose of conferring power of attorney to execute a deed, it should be attested by a notary public or any court, judge, magistrate, consul, or representative of Nigeria. So look at section 150 Evidence Act. If you are having a deed outside Nigeria, it must be notarized by a notary public. If you don't find a notary public, you need to get a magistrate or a judge or representative or consul, more like an ambassador, to do that for you. The reason is because the act of a notary public is worldwide presumed to be regular. Okay, presumed to be regular. Now, we should also understand for that there's what we call a deed poll. So a deed poll, this is a deed which is executed by one party only. So for example, a power of attorney. Never forget this. You may get to see it in your MCQ exams. A deed poll is a deed executed by just one party. And a classic example of a deed poll is the power of attorney, because it is the person giving the power, the donor, that executes the power of attorney. Then an indenture is executed by both parties. For example, a deed of assignment. So a deed poll is more like the opposite of an indenture. Indenture executed by two parties, by both parties. Deed poll executed just by one party. All right. And of course, in a deed, there's always the recital. Recital, the easiest way to understand what a recital is background history. So the recital gives you the historical background of the vendor, somebody who intends to sell to you. Before he sold to you, the land, for example, did not fall from the sky. So the recital tells you the historical background of how he came about owning the land. You said you are the owner of the land. How did you come about owning the land? All right. So that is what the recital does. So we have the introductory recital, okay, and which gives an introduction of everything about the land. Then we also have the narrative recital, the introductory recital, and the narrative recital. The narrative recital states the history of the title and should be limited to facts or matters that are necessary to explain the operative part of the deed. Then what about the introductory recital? On the other hand, this simply indicates the purpose of the document. So narrative, don't forget, narrative recital, history of the title. Introductory recital simply indicates the purpose of the document. Now, you should note that if a defect in title is mentioned in a recital, a remedy for it should also be stated. All right, very, very, very important. All right, so now you should note finally that a deed does not exist in vacuum. It is only an instrument that is deployed to conveyances such as assignments, leases, and mortgages. Now, we have talked about a deed, and this is a course you can listen to while relaxing, while sleeping. You don't have to be in the library listening to this. This is one of the easiest way to learn, and that is the idea behind this series. So the deed generally, as we have said, it has to be signed, sealed, and delivered. And we have also touched on the instances where you need a deed. We've also touched on instances where you wouldn't require a deed. Don't forget, a deed poll executed by one party, an indenture executed by both parties. Example of a deed poll is what? Okay, you can't respond, but you can respond in the comment section. Example of a deed poll, power of attorney. Example of an indenture or deed of assignment. Please subscribe, share this video, comment below, and like it. Also, we want you to subscribe to this channel to tell others about it, other law school students. It makes it easy, makes learning easy for them. This is just one of the courses we've touched. More courses will be touched and explained. Thank you.